Okay, all right. So once again, welcome you all. And today we are having the session on protecting software innovations, copyrights or patents. Ms. Elizabeth Putran is the founder of Putran Associates. Is the speaker for today. And Miss Elizabeth Putran is actually an active member of several international organizations like INTA, that is International Trademark Attorneys Association, USA, and Asian Patent Attorneys Associations, etc. So served on several committees and received award of excellence for the service in the non-traditional marks committee. And she's a co-chairperson representing India in the Global Advisory Council, INTA. And Ms. Elizabeth is also the past chairperson for NTM India, SC, and mentor and technical advisor to several educational and research institutions and incubation centers, etc. One of the founding members of Intellectual Property Association of South India. So this is actually a brief about Ms. Elizabeth. And now over to you, Ms. Elizabeth, for the session. Thank you.
Thanks, Vishnu, for the introduction. And it's absolutely great to be here. So I just before we started, Vishnu sent across some questions that were asked, and I can see a lot of you are in the space of cutting edge technology. So what I'm actually going to try and do in this session is not generally talk about IP. And first of all, I would like to thank GTEC for inviting me and for all of you to joining in. I hope I don't bore you too much with the session. I'm not going to go into it either too technically or too legally, because I'm going to try and put a bridge in place there so that you are able to understand what this patenting is all about when it comes to computer software. So I'm not going to go into any other aspect of patenting other than with regard to software, and also to see how do you balance between patents as well as how do you also get, maybe as an option, also look at a copyright protection for your software. So that is basically going to be how we go on with the session. And I would like to thank my colleagues who are here. I have Parvati, Tanu, and some of the rest of the team. I think I saw someone, but I don't know. So we will be happy to take questions. Like Vishnu said, you can put it in the chat box, but at the end of it also, we'll be happy to, all the questions that are already raised, we'll try and answer as much as possible within the short time that we have. So I'll just straight away jump into the presentation. Just give me 1 second. Yeah. I hope I'm now in a full screen, because always I have trouble with Zoom. I don't have problem, but when it's with Google, I half the time miss out on a lot of things there. So basically the session that we're going to have today is that it's about protecting. So this was the title that I was asked to speak about, given many options, but I think this was something that is a need of the hour as far as all of you are concerned. So it's going to be protecting software innovations. Which way, which is a route to take? Is it copyrights or is it patents? Or in my case, I would say, is it both? So that's about us. Vishnu has given a brief introduction about our firm and what we do. And we are an IP boutique firm. We probably tell people we don't know any other aspect of law. I don't know if it's a good thing or a bad thing, but we've just been specialized in law. And this is my 26th year into IP per se. Yeah, so again, like I said, I am not going to cover patents, what is patentable. I would go into that briefly just to touch the base on software. So I just wanted to tell you one reason why software is coming up in a big way now, because obviously India has been and still continues to be a big source of software. And we have several clients who, because of the patent regime that we had in India previously, do not take any protection in India and straight away just jump to the US or whichever country is allowing them to take protection. Now, when you're talking about software, it is basically a set of instructions, or it's a program where you just instruct a computer to do a specific task. Now, the thing with the industry as far as software is concerned, it is growing at a very rapid pace. And we do have a lot of clients who are coming up in these new technologies. It's actually The other day when I had a session with the Kerala government, they had invited me to speak on the Kerala Tech Show. They had one innovation talk. I was saying that it is such a fantastic feeling to be sitting on the side and watching all these innovations happen, because we, being in the field we are, get to see or get to feel, touch and feel and see an innovation before the rest of the world knows it. And it can be in any field. And software is something where we find a lot of people are coming up with a lot of patents in that field because of the change in the laws that we have. And also it is very necessary, because software being what it is, we need to be able to try and balance what are the possible protections that we can get as far as software is concerned. Now, the first thing that you ask yourself is, each one of you, I would assume, has something or the other to do with software-related patents or software-related innovations. You need to understand the scope of IP protection as far as software is concerned, and then identify what is a relevant type of IP that is related to your particular software. Now, the holistic protection of a software, actually, we always say, a lot of people come and say, okay, is it only patents? Is it only copyright? But there could be trade secrets also, because we have found some instances where the owners of the, say, assume the source code, do not want it to be out as a public knowledge. So they keep it as trade secrets, which has its advantages and disadvantages too. So these are the various things that you need to really think about before you jump into deciding what sort of protection you really want to take for your software. Now, as far as patent protection for software is concerned, see, the basic, before I go into it, I will just touch a little bit on what the patenting aspect itself is. So as far as a patent is concerned, you can get a patent for a process or a product, provided it is novel, it is non-obvious, and it is useful, or rather it has industrial applications. So these are the three criteria as far as a new invention is concerned, if you want to file for a patent for it. Now, when you think about what is a new invention, it is something that has not been published, it's not known to anyone, it's not in the public domain. So it is something that you have come up with. It could be an improvement, or it could be something very original that you have come with. Now, when you look at a software, there is actually, we do have a problem as far as software is concerned, because in Section 3K of the Indian Patents Act, it specifically excludes. I'll just touch on Section 3K in my next two slides, just so that you can see what all is excluded from patentability in India. Now, it says a mathematical, a business process, a computer program. Now, we've underlined the word per se, because that's what it says. A computer program per se or algorithm are not inventions, and hence they are not patentable in India. This is what is even today lying in the Patent Act in that relevant section. Now, here are some of the inventions that are not patentable. I just wanted you to get it. So it's not that you've just been excluded, not that the software industry per se has not been excluded from it. But, you know, anything that is frivolous, contrary to the public order, any mere discovery of anything, if you just mix, we've had people who come up with two things and say, oh, you know, this works, this combination is not known by anyone. Can we file a patent for it? So that is also not allowed. You can file a patent provided there's a synergy and there's an improvement or a new product that comes out of it. Then another thing is agricultural, horticultural methods. So if you look at where we come from as far as a copyright patenting is concerned, it is here, it says software business methods per se are not patentable. Per se, it's there. I've just put in the summary of what is not patentable in India. And anything that has been copyrighted already cannot be patented also, because as I started off in the slide, I said the first requirement is novelty, which is an absolute condition, playing a game. So we have a lot of companies that have games that they come up with. So that per se is not also patentable. Traditional knowledge, anything relating to atomic energy. So this, I just brought it in just to set the, the background for you to see where we are going to take it forward as far as copyright is concerned. Sorry, software is concerned. Now, the patent protection for software, what has happened is they have brought in the word per se in the section. The reason that it has been done is that so that it includes any sort of development or ancillary development that is contained within the software. So it could be, it need not necessarily be a computer. Programs themselves may not be patentable, but a claim to a manner of manufacture. So if you finally have a tangible product, which also requires algorithm or a computer program. So algorithms, like I said, are also out of the purview of patents. They go into the purview of copyrights. Now, the other than that, so if you do have something which actually brings out, like when we go along in the next few slides, you will get to understand a little bit more how we can go about patenting a software. Now, a computer program is definitely, like I just showed you the section 3, it is included in the list of non-patentable subject matter under the Indian law. It is there specifically. A lot of countries don't have it as such in their law, but we do have it. Now, the thing is, as I mentioned earlier, if you need to file a patent for a software, one is it has to be patentable. So we said software, per se is not patentable. And all the other steps of novelty, inventive step, capable of industrial application, all that should be part of your invention for you to be able to claim a patent for a computer software. And also there are certain other, very formal or substantive standards that are there as far as a software patent is concerned. So we always say that a software can't just be an algorithm. There has to be a technological invention to avoid the objection that comes up normally for non-patentability. Having said that, when we file our patents, if it is a software, that is the major part of it, or if we know very well it's a software, we tend not to use the word software for it. We would say a method of doing something, because obviously that is what a software is being used for. Or we would say, we word it in such a way that it does not get hit by section 3, as I mentioned earlier. Now, having said all that, we have this very stringent law in place, which says computer programs out of purview. We've been having a lot of challenges, because I remember when initially I'm talking about the time when we had the software boom, we had a lot of clients who would come to us and say, we want to patent something. And at that point in time, there was nothing we could do. So what we would say, just file a copyright for it for whatever it's worth. Then they would say, no, I don't want, it's all our time and effort. They would even go to the extent of either floating a company in the US and filing the patent in the US for that particular software-related product. Now, what has happened is, this has been happening for a long time. We've all actually represented, including our firm, saying that, we do need to do something about this. Then suddenly here comes along something called the CRI guidelines, which is Computer-Related Inventions Guidelines. Now, that was something that was brought in because of the Section 3 came, because people were finding, actually, when you have an invention and people are desperate enough to protect it, we help them to find a way of trying to protect it. So what happened was, there were 3 sets of CRI guidelines that came in. So they first bought it in 2013, obviously, as a draft. And then there's a gap of 3 years. In 2016, the actual guidelines came out. And then it had to be tweaked a bit because there were some challenges we all had in the patent office. And in 2017, the revised guidelines. So that is what is currently being followed. Now, this CRI, or computer-related inventions, basically it focuses on technical effect and technical advancement. Now, the reason why this is because, if you remember, we are talking about something which says computer software per se is not. So anything what now the Act says, if you have a software which has a technical effect. So my question when I first saw this guidelines, when I saw the draft guidelines, I said, what is the software that does not have a technical effect? Very difficult for me to understand at that point in time, even today, because I firmly believe that we can bring a lot of things, or most of the things of a software under the fact that it does have a technical effect and it is not a software per se. Now, if you look at it, I'm just going to touch upon this technical effect. So a technical effect is that it has a solution to a technical problem, or if there is an error, you find a solution, you have a software that has a solution to it. And the invention should be able to help you to resolve and overcome that error or problem that you have. Like, for example, there's a low bandwidth, or there's low speed. You can have, it's difficult to search for things. A lot of these things. So we've given the examples here. So this is, it's obviously a non-exhaustive list, but just to understand what a technical effect, any of these would seem very simple to you who are in the field, that all of these would in some way or the other come in terms of your software. Now, again, we are talking about technical or technological advancement. That so they say that anything that is a contribution to the existing state of art. So the thing is, a technical advancement will always have a technical effect, but a technical effect need not necessarily have a technical advancement. So I'm sure you understand the point we're coming from. So what these guidelines have tried to put in place is that they are trying to encourage people to come up with something new and non-obvious. So initially what happened was they said software to be patentable has to be attached to a hardware. Now, sometimes that's very difficult. You all understand from the space of a software that sometimes it's just not possible. So these guidelines, the amended guidelines, have actually done away. You don't necessarily need to have a hardware per se. It can be anything. It does not need to have a novel hardware. You can either, say, for example, have a software which you can install in your phone or laptop. So that is just going to be a medium, that particular hardware. So the other thing that it says that, if you have a computer program, you just combine it with a hardware. That will not help you to overcome the objection under Section 3K. You have to have a technical advancement to it. If you go into, some of the cases, I know it may not be, but I thought it was rather interesting, and it will give you an insight into how the courts look at it also. So in this particular matter of Ericsson's case, what happened was, it was a matter that was taken up in the Delhi High Court. And they have said that this was there are a few very critical cases because of which a lot of software companies today are saved and can actually file patents for their softwares. So they have said that any invention which has a technical effect or can prove technical contribution, these are patentable in India. Now, the court held the view that, various experts from different jurisdictions say that India should not follow, which is what we also say. We cannot say that software per se, or rather software, computer-related inventions cannot go out of the scope of patenting. If they go out, then what is the sort of protection that companies who come out with the latest technology have? Why would people want to innovate if you can't protect it? Because if you can't protect it, you can't enforce it. So when you look at it from that aspect, that was one of the reasons why the court also came out with this. Another one is that the addition of the word per se was a very conscious step when they did that, so that genuine inventions which are based on computer programs are not refused patents. I'm not going into whatever is given here, but the court in this case also relied on the CRI guidelines, which were issued by the Patent Office. So here also a patent was granted. It was said that computer software, they also bring in the technical effect or the technical contribution into place. If you're looking at, there's another one, which is, so IPAB is the Intellectual Property Appellate Board, where we file all the appeals against orders that are passed by the Patent Office. I don't know if it's fortunate or unfortunate, but the IPAB has been scrapped, I think, last year. Yeah, sometime last year. So now we only can directly go into the High Court and file it. But here, while this was in existence in 2009, this order was passed. It says that they have laid emphasis on per se. Now, because computer programs per se were not patentable, what they have done is that per se is there so that algorithms or business methods and computer programs as such are not patented. But if the invention is a computer operated or is a controlled technical instrumentation that cannot be regarded if it cannot be, it does not relate to a computer program alone, or there's a set of rules that are there in place, then they should not be allowed to be pushed aside by saying it is not patentable. So these were the judicial pronouncements that were basically given to say that, in this case where it was refused, in this case, a patent was obviously refused, saying that it's a software per se, so Section 3K is applicable, but the IPAB overruled that particular decision. Now, these are some of the patents. So like I said, we have some clients, we used to have pre-COVID times, I think we used to average file about, at least for that client, at least 10 patents every month, at least. Now it's slightly gone down, but they're picking up again much faster because I think everyone had a lot of time to innovate. So here is a granted patent that we have for a client who is basically into artificial intelligence. Look at the title. I've only put the abstract here. It says massive simultaneous remote digital presence world. Now, for someone who hasn't read this patent, there's no way you will understand what that means. Because the reason why, and also look at their abstract. The abstract is a system and method, enabling users to interface. So just look at how it is. It's rather broad. The reason why this was filed like this was subsequent to this. We've got this patent granted. I think this patent was granted recently, last year, if I'm not mistaken. What happened was, they felt that this particular patent had more to it. So what we did was we split it and filed a divisional patent also that is still pending, but this patent has been granted. I just wanted you to get an idea because people keep saying, oh, software is not patentable. There has to be a hardware attached to it. But look at this. This is all software related patents. The next one is also another one that we got granted some time ago. It says selecting virtual objects in a 3-dimensional space. Now, here again, it's systems and methods that are being used, but there is a wearable system. The wearable system is something that it is there so that it's in a 3-dimensional space. So it could be wearable, it could be something I keep on my table. There could be a lot of things attached to it. So this itself is, makes it very clear to you also that this is very much, so when people tell me that, software is not patentable in India, I keep telling them, we've got so many software patents granted for our clients. It's just a particular way of, addressing the situation. But mind you, all these matters went through for hearing. We had to argue, and we have absolutely brilliant colleagues in our office who have actually gone through the process of attending the hearing and got it granted. We have filed all the arguments. And this is the way that the abstract of that particular patent is. So this is just to give you an idea that, when none of you should feel that a patent, when you talk about a patent, it is something related to software, is something that is very much doable. Here is another patent that was, I think it was a 2009 matter. This is an Apple's invention. Again, I'm just putting all this up because today's topic is basically software and, patents or copyrights. Now, the title is for a method for browsing data items with respect to a display screen associated with a computing device and an electronic device. So this is just associated. So this is also another one that is given. This is not ours, but I just put it up there just to give you an idea of what it is. I wanted to actually put up the claims in the earlier 2 granted patents we had, but I think that would open out, and it will take a lot of time to explain that particular thing to you. So, yeah. Now, when someone comes and always says, oh, I want to file a patent, but I know I can't protect my software under patents, can I go for copyright? I always try and tell them, try for a patent first, because the reason is it gives you a broader protection. And also we always find that companies that have patents, more than copyright, the companies that have patents, they always have better strength, especially, for example, we are government facilitators for startups. So we find that all these startups want to just file more patents, and they say nothing works, we will do some copyright for it, but they just want to file patents because it gives them rather good returns. Here we've put reasonable, but it's rather good returns because they are able to commercially exploit that invention after they file a patent for it. Now, like I said, just, all these startups in the small business or MSMEs that are there today, to a large extent, they are dependent on their patents because that is what makes them stand apart. So we have some clients whose IP we have rather valued. We've done due diligence and valuation. And we have actually put it up that their IP or more, their patents are worth more than their actual physical assets. So this is something that we also find. And also it helps you now, you would have all heard about patent pooling and a lot of technology that people come up with. Some of the larger clients, including some of our clients, what they do is that they actually put all the patents together and then they cross-license it or they license it and they do all sorts of things like that. So they get in more investment and they can thereby, expand their business. So we strongly believe that protection of software, which is an integral part of an innovation, is very critical. Now, India is going into a space of digitization. I still remember when I started practicing, 1995, 96, patent to be granted, even now it takes longer time. Unless you file it as a startup, you have a lot of, advantages. But I'm just going back to something which is not part of this. But for example, a trademark, if you used to file, the trademark was valid only for 7 years. But there were times when the trademark registration would only come in 9 years and 10 years. And you had to go back and actually renew the trademark with retrospective effect. But today, we find that trademarks that we file, even in 10 months, we get it registered. So is the case with patents. Now, patents do take longer. But if for a startup that we recently did, it got granted in about a year's time because there are a lot of provisions that the government gives for startups. So I've basically covered what it is about the patent side of the protection for software. Now I'll just jump into the copyright protection for software. Now a copyright, like a lot of people say, oh, I have an idea. Can I copyright it? So yes, you can copyright it, but the idea has to be expressed. Otherwise, how do I know what's in your head? Unless you put it down, unless you express it in some way, there is no way that I will be able to know, or rather the patent office will be able to know that, it is something that is an idea that is there because they can't assess or judge it otherwise. Now, a copyright protection in software, it protects the creativity. So it could be in the source code or the object code. The issue is here, we do have a slight challenge here because earlier you could just give the object code to the Copyright Office. Now the patents are guided by the Patent Office and we have 4 patent offices in India. You can file anywhere and it is valid across anywhere. But as far as the copyright is concerned, we only have one Copyright Office, which is based in Delhi. But everything is done online. It's only if we have physical hearings that we need to go there. But for across India, it's just that. Earlier, they used to accept object code because I'm sure you understand why a lot of people don't want to give out their source codes because it's going to a government office. Now, when we file an object code, they are insisting on us filing the source code also. But that's something that a lot of people or a lot of applicants find it a bit of a challenge to provide that. Now, as far as the copyright protection for software is concerned, these are the section 2 is basically what covers that. It covers a computer program that is there, and this is how it explains it. And also the other thing is it comes under, so it's a very strange thing. Computer programs come under literary work. Now, a lot of people find that very difficult to understand, but this is basically a classification because, it's all written. It's not anything that's depicted in any pictorial manner. Maybe there are graphs, but it will come as a literary work under the copyright regime, which is under the Copyright Act. Now, like I just mentioned, it comes under literary. And as I earlier said, again, I would like to mention again that protection is not for the ideas or the methods of operation or mathematical concepts involved. Now, copyright in a computer program, so if someone copies or infringes anything or uses without authorization a copy of a program or a substantial part thereof, then it is considered to be infringement of copyright. Some interesting judgments again to give you an idea. So Microsoft Corporation went and filed a case against. Before I go into this, the thing with copyright infringement, it's a criminal offense. So we've had instances where we go for raids and seizures and we see people running with their softwares and they throw it even from the top floor. So because they feel that, just throwing it down, these are many years ago, throwing it down will break everything, but you can still, it's embedded in there. We can still find out. And these are in cases of some very expensive software that is installed. What happens is people buy one and then they use it on multiple systems. So when we go so we get what we call a John Doe order, which is against unnamed people, and then go for a seizure, raid and seizure. All this, it's very nice to see all the drama that happens because people are somehow trying to protect themselves by saying, no, we haven't copied. This is the only system we have with it. So, on those lines, what happened here is that the defendant here was making illicit copies of the operating systems of Microsoft and selling it, preloading it into the computers they were selling. Now, the court held that the defendant had to pay damages to the plaintiff because the defendant is in the business of sale of computers. And they are very aware that what they had loaded into their software was definitely an infringing copy. So, for example, they would be selling a Word. We all know how expensive all the Microsoft products are, and we have to get license for each one of them. And each time they keep updating it. So this person decided that he would sell it with the preloaded version. But action was taken and the court held that, yes, damages had to be paid. Now, here again, the definition of a computer program that is given under the Copyright Act. So because I'm trying to bring out the difference between, because computer program is given under the Copyright Act, what does it entail as against when you take up patent protection for it? So here also it very clearly says you have to give the source code and the object code as well in it. Now, there are various ways of determining how you copy it. These are all the various things. But in India, we still haven't reached that stage where, we are able to, yes, we can file for infringement, but there are certain methods that are used to find out how the copying is happening. It's a bit nascent still, but still the bigger companies definitely do have an anti-piracy team itself as far as their software is concerned. Now, benefits of the copyright protection is that you as an owner of the copyright, you have the absolute right to assign or grant a license. So do you have it in the case of patents? That's also an absolute right that you have there for your the lifetime of the patent. Now, the copyright protects the original work, which would be the code. I would think that is a reason why the Copyright Office is coming back and saying that you do need to give the source code there. Now, it can be the copyright also is, it's used to prevent the copying of a software program or any portion. And it's also very economical. If you look at it, I'll just also explain why a copyright as against a patent is economical, but I would still be someone who actually says go for a patent if you can do it. These are the international bodies. I'm not going to go into it. Now, India is a member of the Berne Convention, the Universal Copyright Convention. So the advantage is if you file a copyright, so as far as a patent is concerned, it only has territorial jurisdiction. So if you file in India, it's only valid in India. If you want to file in other countries, you have something that you call the PCT route and then the national phase convention application, several of them. I've not touched on any of those in this little presentation that I have. But as far as the software is concerned, the moment I file a copyright for a software in India, because we are members of the Berne Convention and the Universal Copyright Convention, automatically it gets extended to those countries. And in countries where they don't have, like, for example, we had an instance in Switzerland, where they don't have any laws relating to those states. relating to copyright per se. So the registration that we have in India for copyright is something we could enforce there in the country because all are members of these convention countries. A lot of people are very curious about the software protection in the various jurisdictions. This is as far as copyright is concerned. The patent protection is limited only to those on recordable media and not to computer programs. This is as far as the US is concerned. And they all obviously have the federal law and the state law there. So the federal law says that copyright protection does not extend to any idea, process, procedure, system, but only the expression of such ideas. That's exactly what we also have in India. It has to be an expression. Like it only makes sense if it is expressed. This is a case law, which is the Alice case. It was very popular. I remember when it came out in 2014, a lot of the US attorneys I met were very, when they used to come to us and say, oh, India is having a lot of trouble with software patents, but the US, it's, okay. But this was a case where they were all pulled up because there was a lot of, the patent office was the USPTO was granting patents for software left, right, and center. So there was it went up to the Supreme Court. So there was a very, way that they said that the implementation. So in this case, this Alice Corporation case, it was held that the invention was not patentable. I won't go into the details because it's a rather very interesting, lot of aspects were covered here. So today in the US, we did actually get patents granted for computer-related software in the US, but now there is a little bit of ifs and buts about it. Earlier, it could be anything can be patented there. Now, the two kinds of software-related claims, if you talk about it, this is when you are filing your claims for your patents. It is a claim that directed to an abstract idea. So the computer is merely a tool there, but in the other one, it is a claim that is directed to an improvement to a computer functionality. So there are various claims that we draft for software as far as software is concerned. Now, just because the patent or the software can run on a regular computer will not make it patentable or not patentable. These are some of the things that came up in some of the judgments that came up. So it also establishes that when a software is implemented through a computer, and if it improves the functioning of the computer, it cannot be then considered an abstract idea because it is something that has been implemented. So there could be a possibility of getting a grant for a computer-related software. Then. Here again, when you come back to software protection, again, the US, I am not going to go into detail into any of this because I think all of you would, I've just left that screen on there so that you can just see what are the various jurisdictions, how they look at software protection. So in the US, this is what it is. So it is either relating to how it falls under copyright or how it falls under patents is something. Japan is very interesting. I would like to speak about Japan also here because what happened is in Japan, computer programs, as per the Copyright Amendment Act 1985, yes, it could be protected. 87, they started allowing the registration of copyrights. And there was no examination. So you had to pay, those days, 70,000 yen or something, and you don't even have to disclose your source code. So a lot of people started applying for copyright for computer software. But by 2000, because now Japan, there are, everywhere they are actually modified their laws because everyone has to come in line with the rest of the world. So if one country allows, everybody else also wants to be in the race. So there was a decrease by 2000 in the software copyright registrations because the scope of patenting in softwares had expanded. Then in so there was, every time what had happened was they had come up in the original act that they had. computer program had to be embedded in a hardware. So we remember I said in India also we had the same thing, but this was removed with an amendment. So computer program itself was treated as a product. So which means that any computer program could satisfy as a patentable technology. European Union, because I know some of you have questions, where can you file a patent for it? Where can you file a copyright for computer-related software? Now, computer programs per se, again in EU, is protected under the copyright. And also here, what they have done is they are protected as literary works because, again, they are members of the conventions that we are part of. But under the European Patent Convention, a computer program per se is not considered a patentable invention. I'm sure it sounds familiar to you because we have that in India as well. But when a computer program solves a business, when it solves a business problem using a computer, it's not patentable. But if the same invention solves a technical problem, it is patentable. So there is a slight difference where, as we already spoke about, technical solution to a technical problem is what comes in here. So the last bit would be on, I would like to just compare, because all of you now, somewhere you've got a general idea about, what is it that is patentable, what is it that you want to, when you want to look at the aspects of it. So if you're going to look at it, what, as against a patent and as against a copyright. So the patent, it basically protects the functional or the technical aspect of an invention. But the copyright protects the idea which is expressed. So it cannot be abstract, it has to be expressed. Now, a patent, in patents, we say the first to file is the one who has a right. And it's a statutory right that is given to you by the respective authorities by disclosing what your invention is. For a particular period of time, you are given protection. But the moment you put down, say, for example, I put down my signature, I get a copyright in it. I don't need to file for a copyright application. So the copyright becomes effective the moment a creative work is created in a fixed, tangible form, like when you put it down in writing, when you have. But then the reason why people go and protect it is, how do you prove you were the first one who came up with it? So that is a reason why, even though it is not compulsory to register a copyright to get protection, that's a reason why people go ahead and file for copyright. Now, term of a patent is 20 years. So once it's granted, you have to renew or pay the annuity fees every year. But a copyright protection is a fantastic thing. It is valid for 60 years after the death of the author. So if I'm the one and I live to be 100, which I don't think I will at any point in time, but plus I get that extra time from now, plus another 60 years. So I would say most of the time it goes redundant, but a lot of cases where we file this copyright comes alive again is in case of music, the very old music that we have that comes back again because it's gone out of the domain of copyright protection and goes into the public domain. So here an inventive aspect associated with a software program, that is something now, how do you, it can come under both patents as well as copyright. So that's why I have not specified what it is. Now, a patent protection is definitely, if you ask me, it is a broader protection than a copyright because you have an idea, you have absolute monopoly over the idea that you have covered, over the product. It does not allow anyone to import, sell, license anything if you've got a patent protection for it. But whereas a copyright also gives you the protection, but it only protects the idea itself. So that is what it is as far as these are the differences that I found as far as a patent and a copyright is concerned. In conclusion, I'm concluding faster because I'm sure I don't want any of you to be bored for much longer by me just going in a monologue. So, and leave it open to anyone who would like to ask questions. So a software or computer programs are mainly copyrighted. But if the conditions, so there are certain, like we had already explained, the certain conditions that are there for patentability. If those are satisfied, then the computer programs can be actually protected as patents. And I can vouch for it personally because I've seen a lot of software related products being protected under the patents regime, we ourselves in our firm have got, not just for Indian companies. So the thing is, a lot of these AI and all these technologies that are coming up from the US, for example, and they file it in India because if they need protection in India, they have to file it in India. And we help them to get the grant finally. So it gives you if you have a patent, it gives you a better protection over the use of the work. You can decide how you use the work. But a copyright is the first right. So what happens is, in the case of a copyright, you already have a right. The moment you put a software in place, the moment you write a code, it is automatic. But again, it does not really protect the technicality which is covered under the patents. Now, if you ask me, what is the option? Or what is the best way today, if you're saying what is the best way to protect a software program, I would definitely say it is a combination of both copyright and patents. And if you do that, because each software has a different way of protection that it requires, and you have to use it interchangeably. And the other thing about patents is, so some people fall back on copyrights only for the reason that they would have launched their software. The software is commercially out. So then they can't take a patent for it. So then obviously the only protection available is they have to go back to copyright. So as far as copyright is concerned, even if you publish a document, you do not lose the rights in it. The novelty clause is not there as far as a copyright is concerned. So when you have things like that, if you look at the software products that you have come up with, if already some of them are implemented, say in your client's office, your own office, or elsewhere, then you may be in a position only to take protection for the copyright in that software because it's out there and the novelty condition is lost, so you can't file a patent for it. Where you can file a patent is if you're going to be doing an improvement of that particular product. And then you can file a copyright for it for the one that is already out. But the improvement, if we can bring it under if you satisfy the requirements of the Patent Act, then for that improvement, we can take a patent for it. So it is something that is used interchangeably. And in some cases, people say there's nothing I can do. What they do is they just brand themselves very well. And they bank very heavily on their brand. There are some very I don't know from where all people have logged in here, but I've gone to Technopark several times. I have seen some very strong brands there. We have a lot of clients there too. So you see, they actually put a lot of emphasis on their brands as well. And the software that they actually sell to the consumer, it is sold for the efficacy of the product or how efficient it is. But the brand is also something that is very critical. So when we are talking today about software, is it patent, is it copyright? It is a combination of both, but also it is how you brand, your branding image of it, or like we call it in our language, trademarks that you use for it. That is also something, because some of the trademarks that we know, when we hear Windows or you hear, anything that who it belongs to, where it is coming from. So that is one other aspect of protection, which I have not gone into here in detail about. Now I would want to ask if any one of you have any questions, if there is anything that you would like to ask me, or if I have explained well enough, I'm very happy about it. So I also have my colleagues here who will also be happy to take questions. And thank you very much. So if there is something that you specifically want to ask me, please do go ahead.
So, Ms. Elizabeth, so I think I have actually shared you around a couple of questions. So I think that has been addressed, or whether.
Yeah, Parvati. Okay, so here I have a question from Sanal. It says Sanal Softland. So I assume Softland is the company. Copyright requires any kind of protection. So to answer your question, Sanal, copyright is the right in, it automatically exists the moment you set down, okay, I have a comment from my office which says Soflan is a client. I like that. Okay, Sanal, I apologize for not identifying that. But yes, copyright can be protected by filing for registration because, like I said, it helps you if you have say a software product and someone is infringing it. If you go to a police station, this is my personal experience, with your copyright registration certificate, the police will come with you to raid and seize. So that is something that is the reason why a lot of people apply for registration for copyright. I hope that answers your question. Maybe I will take the questions that came in. Let me just. Okay. Vishnu, do you want me to call out the names or just say what are the questions? Okay, so can I just go out and say Jaren has asked a question. What are the different stages in obtaining a patent? Now, the different stages are, the first step is definitely you need to ascertain whether this product or process that you have is already in existence. And novelty is not just in India, it's across the world. So the first step that we do is we do a prior art search and then see what are the similarities between what already exists and how yours is different, and actually lay emphasis on those differences and file a patent. So we do an assessment on the patentability. The next stage is we will file the application. So if your patent, you're still working on the invention, then we actually file what we call a provisional application, which talks about the bare gist of the product. And then from there, you have 12 months time because your protection will run from the time of filing the provisional. You have 12 months time within which to work on your invention and then file the complete specification. After that, the patent is published and then it's examined. And if there is no hearing, then it just directly proceeds to grant. So that is what is the steps for, in a nutshell, that's the steps for obtaining a patent. There is a question by Jason which says, how can I implement this? I apologize, but it's not clear. If you would like to put in the chat box what that is, then I'll definitely be able to help you. Okay, so I'll go through the questions first, which actually I'm able to answer, and if anybody else has anything, then. So there's a question from Dilip which says how to identify an idea as patentable. So like I just said, the invention has to relate to a product or a process, and it has to satisfy the 3 criteria. Now that is novelty, non-obviousness, and industrial applicability. And also section 3 that we said it should not fall under non-patentable inventions. So basically when we do a prior art search, we will be able to assess the patentability. We will be able to tell you based on what already exists or based on the fact that whether it is a non-patentable subject matter, that is something that will come out in a prior art search. Monisha has also asked, what are the process for taking patents? I just explained that, the flow of it from starting from a prior art search. How an Indian product, which we were using for past many years, gets patent in the name of a person with a different nationality. It shouldn't be happening, Manisha, so I don't know ideally what that would be. But if you have been using a product, say, for example, look at basmati rice. What has happened to it? Somebody has gone to the US and filed. They were not aware. They granted it. But today we have the traditional knowledge digital library in place. Even the US examiners actually look at that when they're giving, because they've had a lot of problems with people going and filing patents for something that was known in India before and taking a patent for it in the US or other countries. So now they have a system of cross-checking and things like that. So since, if very critically, because novelty is a criteria, a published patent is actually not entitled to patent. Even if it is not published, if you have brought out the product in the market and someone is going to get a patent for it, you can always challenge it. That's how we have challenged some of the patents. Maria has asked to understand about software innovations, copyright, or patent. I'm not sure, Maria. After the session, I wonder what you will go for. Will you go for copyrights, patents, or both? Anwar says how to patent a software application. The same process that is mentioned. You go through the process of the prior art search. We ascertain for you whether it is a computer software per se, what we can do. So we normally try and guide the applicants through the entire process of how to get over the non-patentability issue that may be there. Matthew Philip has says under more about IP registration. I'm so sorry I didn't get that, Matthew, if you can help me. Now, which countries allow software patents? We have touched on it. I've not touched on all the countries. I think Regin has asked that question. A lot of the countries say software patents per se not allowed, but if there is a technical advancement, a technical effect, then that can be to that extent. Krishna Prasad has asked, can a monitoring application be patented? We will definitely have to see what that invention is all about to be able to actually give you a proper assessment on it. Nino's question is how software is protected. So obviously patents and copyrights, as we just discussed, these are the two aspects that you can look at. Copyrights are for software and patents is for product. This is from Dr. Nidhi. It is interchangeable. Copyright is for both or software. You can file both as a product under the Patent Act, or you can also file it as a copyright, as I just explained in detail. Is copyright, so Archa has asked a question, is copyright valid in the software segment? Yes, it is valid. It's definitely valid. It is just that how do you prove somebody has copied? Then you have to go to court with your source code and say, this is an exact copy of that. To that extent it is. But unlike that, in patents, it's much easier to prove if there is an infringement, unless someone bodily lifts your entire code and takes it away. Then it's very easy to do that. Simon, I hope I have got it right. Simon, no. How do companies protect software innovations? So software innovations can definitely be protected. Again, I hope the session helped you there to tell you how you can protect. So as far as I can see, I've been looking, scrolling down. I'm not sure, have I missed anybody else's questions? I'm not sure. I was just going through my entire thing here. Just wondering if any of you, anybody else had any more questions. We are happy to take.
So if you have any questions, kindly unmute yourself and ask Elizabeth.
There's actually one thing I'm very happy about, Vishnu, at the end of it. Maybe my session actually gave people all the answers to their questions.
Yeah.
which is actually brilliant, right? This reminds me of when I recently, we did a session for because we do a lot of sessions for these colleges and universities and startups.
Okay.
And we find that with startups, actually, they have a lot of questions. Okay, I see Mithun. Okay, he has. I thought he was trying to unmute. Okay. So we find that there would be no. So we're always very happy thinking that the session was informative and people had no other questions. So I'm not also sure if everyone here is in the software industry or software related. So if you do have anything else in terms of patenting or copyright or software or design, any form of IP, happy to take up that question as well.
So I think there are no other questions or queries from the members.
Yeah, I don't think so, Vishnu. So
okay.
I had actually left some time because I thought if anybody wanted to ask questions.
Okay. So I think it's time for winding up the session, right?
Yeah, I'm good unless you want anything specific.
Hmm.
So, I mean, the thing is, we do have, what actually happens is that we are happy to take up anything, and I will actually give you, so that this would be our mail ID. I have my mail ID here as well as the office general mail ID. And for, people who are already our clients, because we see several of our clients here already. So if, you all have the respective office IDs, and I have my colleagues from the respective office also here. So these are our mail IDs. This is actually the Chennai, but if you send it out to IPR at Footprints, there will definitely be somebody. Anytime you can ask any questions.
So is it possible that I can share your presentation to the participants who attended today as well as other companies also? Is it possible that you can share that presentation with me?
Yeah, we can do that, Vishnu. I have not, it is a very, those points are not, if you're okay with just those points, because just those points may not help you. Maybe we may need to do, I'll just speak to maybe Parvati and see how we can put it for you in a format which is easier for people to understand. Because, when it's a presentation, I just have my bullet points in there.
Correct. So that would help, yeah.
Sure, can do.
So that I can share with all the companies as well as the participants who have joined today. Okay.
Happy if it helps someone to, think about patenting, then that's the best thing that would happen. Yeah.
Okay, great. Yeah. So thank you, Elizabeth, and thank you, the team Parvati and Tanu also coordinating this one. So thank you on behalf of GTech Member Focus Group for having this session. It was very informative session, and hope all the members have actually got benefit out of this session. And thank you. And I think I can actually share you. I think I already have shared the list of companies who have actually registered today. So the questions which was actually there, you have already addressed to that also. So you may work out the presentation so that which I can actually forward to all the companies also with your contact. Okay.
So happy to do that, Vishnu. Happy. Anytime anyone needs any help, happy to help out because.
Great. So thank you so much, Elizabeth.
Yeah, thank you everyone for listening very patiently. So I know it's the middle of your working time, but thank you and thanks for inviting again, Vishnu. Yeah. And I would like to thank my team also for helping me out with this whole thing. Thank you.
Thank you. Thanks all. Bye.
Thank you. Bye.